Welcome us all back into our adult forums here for July. We are very excited to be gathered together. A little bit of housekeeping before I do some introductions. We are worshiping in the gym for the month of July. So what we are asking is anyone who's here for the adult forum, if you will enter the gym for worship through the servery. So in a few moments when I go to sound check in the gym, I'm going to close those doors that go out into the rest of the Jones building, encouraging everyone that is not here with us to enter the sanctuary through the back of the gym. You can, of course, we can go in and out of those doors, but we encourage all of us to enter in through the servery, and there should be ushers there with bulletins as we gather together for worship. We are super excited today. I am super excited to welcome the Tennessee Innocence Project, in particular Quinn Carlson and Connor Weber, who are both staff attorneys for the Tennessee Innocence Project. Quinn is a native of Connecticut, but calls Memphis home. A graduate of Loyola Law. Sorry, why did I trip? It's the two L's together. Three L's, Loyola. She's a graduate of Loyola Law in New Orleans and served in private practice for 17 years in healthcare law before joining the Tennessee Innocence Project earlier this year. And Connor is a graduate of Vanderbilt Law School and has gone on to serve once his graduate and worked with convictions. He did some insurance litigation before coming to join the Tennessee Innocence Project here in 2022. Connor is, many of you may know, the grandson of Bruce and Joyce Weber, which is part of our connection with him and how we got connected to have the Tennessee Innocence Project come and speak to us today. We are very excited to hear about their work, both nationally and particularly here in Memphis. And so before we begin, I'd like to open us with a word of prayer. Let's pray. Gracious and loving God, we thank you for the gift that you have brought into our lives, that have moved through us, the way your Spirit has blown in us to bring us here to this moment. We ask that you open our hearts and minds to hear you, to hear once again your call, to speak for those with no voice, to see those who have been pushed to the side, and to fight for justice for all of those who have been oppressed. Help us to feel your Spirit in our presence and guide our hearts and minds as we continue to learn how to follow you. Amen. I am happy to turn this over to Quinn and Connor.
Good morning. Good morning. Thank you all for coming at 9 a.m. on a Sunday to hear about our organization. The Tennessee Innocence Project is a non-profit firm in Memphis that's dedicated to exonerating the innocent people. It was opened in 2019 by our executive director, Jessica Van Dyke, and our first office was in Nashville. In fall of last year of 2023, we made a strategic decision to open up an office in Memphis because most of our applicants are from this part of the state. And due to the locations of prisons and courtrooms and how often you need to deal with the district attorneys, investigation, evidence, it is very important to be near where the convictions occurred. We have our most applicants from here. We are the only full-time organization in the state of Tennessee that is dedicated to helping overturn wrongful convictions. And currently we have 5 attorneys. We have 3 in our Memphis office and we have 2 in Nashville. And then we have several unpaid law school interns and externs who provide invaluable services. At the Tennessee Innocence Project, we define a wrongful conviction as someone who is factually innocent, convicted of a crime that did not occur. So our cases are situations where someone did not commit the crime as opposed to such as a procedural defect, which some of you may hear in a court, like where there was, like recently, I think the Alex Baldwin case was overturned or dismissed because the prosecution withheld evidence. Those are, while some of our cases involve that, it's that our clients are factually innocent. We've done extensive investigation to determine that. While wrongful convictions are usually a result of multiple factors in every case, The 5 leading causes of wrongful convictions are eyewitness misidentifications, false confessions, police or prosecutorial misconduct, flawed forensic evidence, or perjured testimony. And all these things can happen in one case, or it can be a variety of cases, and it can happen at all different levels of a conviction. Just to give you an idea of the scope of this problem nationwide, and then we'll go down to Tennessee, is that the research shows that approximately 4 to 6% of convictions are wrongful convictions, which means those are innocent people in jail. And African Americans are 7 times more likely to be convicted than an innocent white person. As of 2023, Tennessee had more than 24,000 felony convicts in prison. So if you do the math, that's an extensive amount of people who are likely innocent in prison. Tennessee also has one of the highest rates, 9th, of people incarcerated per population. So we have a massive incarceration here, and we have lots of potential clients, you would say. While the Tennessee Innocence Project opened our doors not until 2019, the Innocence movement nationwide has really been going on since the early 90s, late 1989. And this is just to give you an idea of how many people around the country are working on this. There's been more than 31,000 exonerated people. Only 34 of those are from Tennessee, and 21 of those occurred in the last 10 years. And we can proudly report that 6 of those are our clients, and hopefully we have a few more. We've had some really important, substantial hearings in the last couple of weeks, and we are hoping to get some positive outcomes. That it's not over till the good thing happens. So if you do not win at the original criminal court level, we're going to go to the next level and do what we can to the extent possible. And just to give an idea of kind of cost-benefit analysis, the average daily cost, as you can see, per inmate is $80, which is almost $39,000 a year just to house people. Now we have kind of 3 main tenets of our activities, which are 1, to investigate and litigate wrongful convictions. Our clients go through an extensive application process. It's two phases. They submit an initial paper application, and if they pass during that, we find them acceptable, we go to another really substantial second application that requires a lot of detail, records, anything they have. And then there are cases that we research or investigate for almost over a year before we decide to take them. We have one case that we've been looking into, I think, since October of last year, that we just accepted on Thursday, because we really need to make sure that they fit our parameters of actual innocence. The investigation usually involves obtaining a ton of records, which is never easy, from the Memphis Police Department, the DA files, and then we have a private investigator who works with us who's amazing, and he helps us locating individuals, and then we often either go out and meet with them with him, or he does some of the initial due diligence. We also like to train the law students and attorneys to litigate these cases, and that comes in the form of our interns and our externs, as well as outreach, doing CLEs or helping other people. Training other lawyers to do this work. A CLE is a continuing legal education course. It's an acronym, but the idea is just each lawyers have to take a certain number of hours each year, and so we provide training on the topic. And then the advocate for policy and changes to create remedies and resources, that's twofold. The procedural mechanisms for our clients to get into court again, a lot of them have already exhausted all of their appeals or ways to overturn their conviction. Is the procedural mechanisms as of now are kind of complicated and vague, and there's always needs to be work done to help kind of clarify it and perhaps even give them more avenues for relief. And then also the remedies once they're out, and resources. I mean, people have been wrongfully incarcerated for 20, 30 years. You can imagine what it is like to go back to where we all are today. I mean, there were little things from no cell phones to there wasn't even necessarily the World Wide Web, but on top of that, family members are gone, your support services are gone, you've had, the trauma associated with being in prison. There's just a lot that goes into helping facilitate these people having the resources they deserve to move forward with their lives in their way. And our clients are all doing great, but that takes, as more clients have been released, we realize that also needs there needs to be some type of support services for them after. So this is just an idea of the scope of what we've done with the few people we have on our staff. We've done 10 presentations so far, and we've reached almost 1,500 people. We also will do presentations at non-law firms, other organizations, anyone who's interested, like a lunch or learn. So if anyone would ever like us to come visit again, let us know. And then here's our current caseload. We have 12 open cases. We have, as you can see, our most are in Shelby County, and I think we have one more now. And the 12 is really limited, is due to the scope and breadth of these cases with only 5 lawyers. And then we have had, this is the number of applicants we get. 180, just going through all of them is extensive. We have an amazing intake coordinator who does a lot of the background research, and we have a meeting once a month to kind of go over new applicants once they've submitted it. And this is kind of our Shelby County scope, so you can see why we felt like it was important to move into this area. All right, now Connor gets to do the fun part where he gets to talk about an actual client. But thank you so much, and here you go.
Thank you, Quinn. My name is Connor. I'm a staff attorney with the Tennessee Innocence Project. I started working with TIP in the Nashville office, and I moved here last August to help open our office here in Memphis. On a personal note, it's great to be here. My grandparents have been members of the church for 44 years. And on another note, my wife and I are expecting our first child. Our daughter's due at the end of the month. And she will be in daycare at Idlewild eventually. I'm going to walk you through our first exoneration in Memphis, Artist Whitehead. I want to make sure everybody can see the slides. Can everybody see it? Would it be better if I moved this way? I don't know, maybe that's worse. Better for you, worse for you? Maybe I'll just stay in the middle. Okay. Mr. Whitehead was exonerated back in January. On the left there, you can see Mr. Whitehead as he walked out of the courtroom with his arms up. Of all the days to wear orange, your exoneration day is an interesting choice. In the middle is a photo of Mr. Whitehead when he was released from prison. There's a little bit of a gap between when you're released from prison and when you go back to court to be formally exonerated. So those were different days. And then on the right there, you can see Mr. Whitehead at Fleming's enjoying some well-earned surf and turf. As I said, Mr. Whitehead was our first Shelby County exoneration. It's a case that we worked on for years before we opened our Memphis office. You can see the breakdown of the resources that it took to secure Mr. Whitehead's freedom. Time is obviously our biggest expense. Between all attorneys who worked on this case, and that includes some law firms who worked pro bono, there were 3,754 hours. We don't charge for our services, of course, but if you assume about $300 an hour for legal work, that's a little over $1 million in time alone. And then other expenses approach about $40,000 for Mr. Whitehead's case. So let's get into the case. Mr. Whitehead was convicted of an especially aggravated robbery that took place at the B.B. King's Blues Club just down the road back in 2002. This was a very serious crime. It made the news, and let's take a look at how the news covered the crime right after it happened.
In the morning, the ministry was filled with clothing and beverage vendors making deliveries and he was managed. Thursday morning, May 9th, the delivery was interrupted when a gunman walked into the club. Investigators, the gunman walked up and down the street for 15 minutes before entering the club.
Start this over.
In the morning, the ministry was filled with clothing and beverage vendors making deliveries and he was managed. Thursday morning, May 9th, the delivery was interrupted when a gunman walked into the B.B. King's Blues Club. According to investigators, the gunman walked up and down the street for 15 minutes before entering the club. When he decided to move, he grabbed an empty produce box from a trash can and carried it into the B.B. King's like he was making a delivery. You don't know if he's someone from the area where you probably didn't suspect that. He's definitely someone that had knowledge of what's going on at that time in the morning. The President Energy came from the back and went down to a lower level. Once downstairs, he was confronted by the cook. The suspect shot the cook in the head and demanded to be taken to the office. The robber tied up several employees with a phone cord and took their money and jewelry. He didn't hesitate to shoot, so of course we consider him extremely dangerous and violent. And prior to leaving, he threatened to kill the remaining employees in there. Investigators think the robber thought there would be a lot of money in the club because it was the week after Music Fest. Steve Dawson, Fox 13 News.
I know that might have been difficult to hear. Now what? Uh-oh. How do I get back to this? There we go. All right, so the basics. A man walked into the B.B. King's basement. He shot the chef. The chef survived, thank goodness. This was not a murder case. It was an aggravated robbery case. He then tied up the staff and robbed them. There is no physical evidence recovered at this crime scene. That's hard evidence, like DNA, fingerprints, ballistics evidence. So this was basically an old-fashioned whodunit. The police had no leads, and it was going to require diligent and careful detective work. The real question in this case is, how did the Memphis Police Department arrive at Artis Whitehead as a suspect? Let's take a look at what the witnesses told the police about the robber. Witness 1 told the police the robber was 5'8", about 150 pounds, with a scruffy beard. Witness 2, the robber was 5'4", 135 to 140 pounds, rugged like he had not shaved, long, extended, noticeable jaw, little mouth because he was a little man, and neglected. Witness 3 is my favorite. Witness 3 was 6 feet tall, and he described the robber as 5'6" to 5'8". As a 5'8" man myself, I have always known that the 6 foot and over crowd looks down on us, and this is proof. Anyway, witness 5, sorry, go back. Witness 4 did not give a statement. Witness 5 said that it was that the robber was between 5'8" or 5'9", slim build, and witness 6 said 5'9" or 5'10", slim build. So this is what the police put together. The police put together this composite description: a male black, 35 to 40 years old, 5'4" to 5'8", 140 to 170 pounds, beard, and a small mustache. That description is really the only evidence the cops had to go on in this case. The problem with Mr. Whitehead as a suspect is that he was 6'1" and 200 pounds back in 2002. He was also very muscly. He was sort of a gym rat. He was a muscly 200 pounds. Here's a picture of Mr. Whitehead back in 2000 or around 2002, standing almost as tall as that SUV. Here's again a picture of Mr. Whitehead from around the same time. He's filling up a large door frame. This is not a small man. And again, here's a photo of our robber. This is CCTV footage from the robbery. So, how in the world did the Memphis Police Department arrive at Artis Whitehead? Here's how we get to Mr. Whitehead. On January 24th, 2003, so this is several months after the crime took place, a Crime Stoppers tip came in from a man named Gregory Jones, which connected Mr. Whitehead to the B.B. King's robbery. For anybody who doesn't know, Crime Stoppers is a phone tip line people can call to anonymously report criminal activity. If the information leads to an arrest, Crime Stoppers may pay you for your information. As the Tennessee Innocence Project discovered during its investigation of Mr. Whitehead's case, this anonymous tip was the only reason police began to suspect Mr. Whitehead. So we started to take a closer look at this Crime Stoppers tip. This is the first and only time the Crime Stoppers tip was mentioned in Mr. Whitehead's court process. Right before Mr. Whitehead's trial was set to begin, then Assistant District Attorney Wyrick addressed the court saying, "Judge, this may amount to nothing, and we may just be the last to know. This defendant was developed as a suspect in this case by an individual by the name of Gregory Jones. When Gregory Jones was up in the robbery office on another unrelated matter, he saw a picture of the defendant and said, 'I know that guy.' And from that's a Crime Stoppers tip. And that they got a picture of the defendant from his federal parole officer, and they put him in a photo spread, and that's when people began identifying him. This is a little confusing. When an informant comes into the police department to speak with police and identify someone in connection with a crime, that is not a Crime Stoppers tip. That is an informant whose existence and identity should have been disclosed to Mr. Whitehead's trial attorneys well in advance of trial. So if Greg Jones was speaking with detectives in their offices, how did this become a Crime Stoppers tip? We actually spoke with Greg Jones. This is an excerpt from a letter Mr. Jones wrote as part of our investigation. In the letter, Greg Jones explains that when he implicated Mr. Whitehead to the police, instead of documenting that Mr. Jones was an informant in the case, detectives instead had Greg Jones call Crime Stoppers to place the tip anonymously, thereby shielding Greg Jones's identity from Mr. Whitehead and his attorneys. This is, in my opinion, this is a little bit of editorializing. This is something like money laundering. The police didn't trust Greg Jones. He was not a reliable witness. They didn't want to put him on the witness stand. So to bolster his accusation of Mr. Whitehead, they routed the tip through Crime Stoppers, where it would forever remain anonymous. The police then revisited the victims, none of whom was able to make an identification. And some of these victims identified Mr. Whitehead in a photo lineup, as you can see here. Mr. Whitehead is bottom right, and he's been circled in red. And here you can see one of the witnesses has written, "This is the man I saw outside B.B. King's and that shoved a gun at the," and the rest is sort of illegible. This evidence, the witness's identification of Mr. Whitehead in these photographic lineups, that is the evidence that convicts Mr. Whitehead at trial. That's what the prosecution takes to the jury and says, this is our guy. Obviously, you can see in this photo, again, bottom right, that Mr. Whitehead does not match, you cannot see that Mr. Whitehead does not match the physical description. The witnesses are only looking at a picture of his face. They're not looking at his 6'1", 200-pound, very muscular build. So let's take a deeper dive into what we discovered about Greg Jones and why he was talking to police in the first place. In 1991, this is sort of a personal history of Greg Jones. In 1991, Greg Jones robbed a Burger King. 3 years later, he robbed a bank and received an 8-year federal sentence. He was released on May 9th, 2002, but on November 14th, he was arrested for 2 separate armed robberies. At this point, he is in a mountain of trouble. On December 5th, 2002, he met with detectives hoping to strike a deal. And in January 2003, he met with Memphis police multiple times per week. On January 24th, Greg Jones implicated Artis Whitehead with that Crime Stoppers tip. Greg Jones was indicted for his robberies in federal court on February 18th, 2003. In August of the same year, a Memphis police detective testified in support of Greg Jones in federal court due to his assistance in implicating Mr. Whitehead. On September 26, 2003, the feds offered Greg Jones a deal. This is in his bank robbery case. And 3 days later, Greg Jones implicated 2 men in a robbery murder known as the Union Planters homicide. This is a totally different case. So Greg Jones gave information about Mr. Whitehead. He also gave information about this Union Planters case. Mr. Whitehead's trial began on November 10th. And on November 21st, Memphis police began investigating the individuals Greg Jones implicated in the Union Planters homicide. And what they found is that both men Greg Jones implicated had ironclad alibis. They were out of state. In other words, Greg Jones lied to save his own skin. When this was brought to the attention of the federal court, the judge denied Greg Jones' sentencing reduction because of the strong evidence that he lied. And I'll skip ahead here. You can read here, the judge denied Mr. Jones' sentencing reduction, saying, quote, "They're providing a false information which can lead to the prosecution of an innocent individual in an extraordinarily serious case, is to this court a very, very troubling thing. Well, you can say that again. Okay, going back to the timeline, the same month that the federal court denied Greg Jones's sentencing reduction in federal court, Artis Whitehead was convicted and sentenced. I'm sorry, he was convicted earlier, before this, but his sentencing was on March 22nd. He was sentenced to 249 years in prison. This is argument from Greg Jones's federal sentencing. You can see the quote here. There were no other leads prior to Greg Jones's involvement in this case. They're talking about Mr. Whitehead here. Greg Jones today admits that he lied. He remains in federal prison, which is where we found him, and he's set to be released in 2041. Greg Jones also admits, in addition to lying about Mr. Whitehead, he admits to lying about the Union Planters homicide. You can see here he wrote a letter to us. He says, one more question. How is it that the victims of the B.B. King nightclub robbery could positively identify Artis as being responsible for that crime when he is not responsible for that crime? So that's Mr. Whitehead's story. When the Tennessee Innocence Project returned to court, we went before Judge Jennifer Fitzgerald, and we brought evidence of Greg Jones's involvement and his admission that he lied about Mr. Whitehead. We also spoke with the eyewitnesses who identified Mr. Whitehead at trial, who agreed that Mr. Whitehead did not fit the description of the robber. Some of these witnesses also told us that the police either pressured or influenced them to identify Mr. Whitehead in the photo lineups. We also presented expert testimony on a variety of issues in this case. Dr. Bolcavera and Dr. Neuschatz are eyewitness identification experts. Jack Ryan is a law enforcement best practices expert. He took some pretty serious issues, you might imagine, with laundering an informant through Crime Stoppers. That is not best practice for law enforcement. We also had Judge Mark Fishburne from Nashville, an expert in legal representation and effective assistance of counsel, and Lucian Pera, an expert in legal ethics and professional responsibility. Here are some photos from Mr. Whitehead's hearing. Credit to the commercial appeal for these. They did some really amazing coverage of Mr. Whitehead's case if you'd like to learn more. Let's see. There's Mr. Whitehead with Jason Gitchner, another attorney who works from the Nashville office. There's Mr. Whitehead speaking with Jessica Van Dyke, our director, on the right. This is Judge Mark Fishburne testifying in support of Mr. Whitehead. This is one of the victims from the crime. His name is Arthur Riley. He testified in support of Mr. Whitehead at the hearing and acknowledged that his identification of Mr. Whitehead was incorrect at the time. Similarly, here's Mark Hearn, another witness and victim who testifies similarly. That's Judge Fitzgerald. And then lastly, this is Mr. Whitehead as he walked out of prison. He spent 21 years in prison for a crime he did not commit. So that's what it takes to prove a case of innocence in Tennessee. I don't know how we're doing on time. We're way early. But briefly, I wanted to shout out our upcoming fundraiser at the Hilton. It's on November 7th. Details can be found on our website. And of course, you can always support us directly on our website as well. I was supposed to leave 10 minutes for questions, but we got through that way faster than I thought. So we have much longer for questions now if anybody has any questions. Go ahead.
Certainly you must have some people who are seeking your services who are actually guilty. What percentage of the people who come to you do you not accept?
I don't have numbers specifically on how many we don't accept. Certainly it's true that we reject a lot of applications. Often when we reject an application, we're not really making a determination about guilt or innocence at that stage. What we're really saying is this isn't the kind of case that we feel that we can win. That's usually what we're saying. Sometimes, of course, there is very powerful evidence of guilt, and those are typically pretty easy cases to dismiss. But yeah.
Some people leave themselves out in the initial application, like they will admit they're guilty, but that the sentence isn't fair or something. So there is a percentage that are immediately, they're put to the side because there's just not enough resources to
or they don't meet our application criteria.
So I know our DA's office has a new review unit kind of thing. Do y'all have a relationship with that office? And I know Nashville's had one longer than we have, or talk about that and is that a good thing, a bad thing? Like, how should we feel about that office?
Yeah, it's a good thing.
It feels like that to me.
Yeah, it's a good thing. They're called CRUs, or in Memphis it's called the JRU, the Justice Review Unit. In Nashville it's called the Conviction Review Unit. What these are, in case you're unfamiliar, these are sort of in-house innocence projects that prosecutors in certain jurisdictions open to look at usually applications of wrongful conviction. It is always a good thing when the state will stand up in court and agree with you that your client should get relief. That is always a good thing. We work with the JRU here in Memphis. We also work with the CRU in Nashville. The CRU has existed for a little longer, so we have a pretty close relationship with them. Memphis is newer, so we're still building our relationship with them, but we have a very strong relationship, and we work with them as often as possible. Their role, I believe that they supported Mr. Whitehead's case. They didn't actively participate in his case, but they did support his petition to the court.
And they didn't find it, y'all found it.
This case, yes, that's right. Yeah, we originated this case.
The process is we usually submit it to them, and then they do their own independent research, and if they would like to I don't know if pair isn't the right word, but if they do want to work on it, they will do their own research, and then they tell us if they're going to oppose or reject.
Yeah.
Right now, we have a case set in August that they've taken, that they're investigating. We just went with Lorna, who's in charge, and met with our client for a long time, and she interviewed him. And I think they're on board with two of our other cases currently. Yeah, so 3 of the ones we have pending in Shelby County, they have researched independently and have agreed to not oppose, and they also support our petitions.
So I guess key facts are they've been convicted, and for you guys to take the case, there's clear evidence that they are innocent.
Mm-hmm.
So is there a process problem, or is, it's just in terms of the appeal process for somebody being able to get back into court, or where's the dysfunction?
You mean in the system?
Right.
Well, that's a good question. How long do you have?
Cliff Notes version.
Yeah, Cliff Notes version. You're obviously able to raise certain things on appeal in other appellate avenues. So you have your direct appeal. We don't that's your appeal right after you're done with trial. You're saying that the evidence was not sufficient to convict me at trial. We don't take cases on direct appeal. We only take cases after your direct appeal is over. We will take you if you're in your original post-conviction process. We very rarely get applicants who are in original post-conviction. So we have to go back and try to reopen their post-conviction, which is difficult, and there are only a certain number of ways you can do that. Or we have to go through a different avenue, which is the writ of error quorum nobis. That is a legal mechanism by which you can bring to the attention of the court new evidence that proves innocence. There are some stringent requirements for what evidence qualifies under quorum nobis, but that's the general gist, is that you're bringing evidence that was available at the time of trial that would have made a difference in your case. Where is the defect in the system? I think if I could identify one, it would be. I think I would have to say that the defect is at the trial stage. We need to get this right on the front end. Even if you can win on direct appeal, even if you can win in your post-conviction, that's before you get to our office. We need to get this right. That's, I think, where the true defect is.
And then the other, so he was talking about the quorum nobis, so it's either facts that would have made a difference at trial, and then the other one is new scientific evidence. So that's where you can reopen the post-conviction. So that would be DNA, which I'm sure most people have heard about, things of that nature. But there's some nuances like false identification. Is that new science since we now understand false confessions differently? Connor just worked on a really big one in Nashville that involves shaken baby syndrome, and just kind of our understanding of neurology biology and development of a premature baby, that was newly discovered science. So it's kind of, that's it. There's no say, like, you have to have something new, and it has to be substantial. And I agree with Connor. I think if you put garbage in, you kind of get garbage out, so.
Which leads to my question. Since our judicial process is adversarial and it comes down to winning and not justice, I don't know if there's a question somewhere in there. But
Yeah, I get you. Yeah, the adversary process is not designed to be win at all costs. It's not about cheating the rules. It's about and I'm really talking about prosecution here. It's about following the rules that are in place that protect defendants from this kind of thing. For instance, not withholding the identity of an informant who provided the only connection to the client.
Is there a crime in there? Like, it feels like that should be a crime.
Feels like it. Yeah. I don't know. Maybe technically it's a crime, but nothing will come of that, I don't think. So it's certainly misconduct, in my opinion, and in the opinion of some law enforcement experts who have weighed in on this question. So, yeah. Does that answer your question? Yeah. Yeah, I mean, it is about winning. That's certainly true. It's not about winning at all costs. Maybe that's a problem with perception that some people run into, because you certainly see cases where, and I'm thinking of one of my cases now in particular, but where you see that the prosecution is laser focused on getting a conviction, and that is all that matters. That's it. Constitutional rights of defendants need to come first. That's number one. If you can't convict somebody without violating their rights, you can't convict them. So.
Do you know how many states have, I know Texas had an Innocence Project as long as 20 years ago.
Mm-hmm.
One of the cases that made national news was called Tulia, where a lot of black people were sentenced, and lengthy. Pulitzer was involved in the expose of it, but how many states have an Innocence Project? Or it's probably not connected at all, is that correct?
Yeah, so the way that the Innocence Project works, the Innocence Project is its own group. We are not formally connected with them, although, of course, we work with them. They're in New York. They take cases where DNA is involved. That's really what they specialize in. Then there are chapters in most states. I believe that Alabama doesn't have one.
And Mississippi, I'm sorry, I was Googling it. I couldn't find it. Mississippi doesn't have one
Yeah.
either.
And I think those are the
And
only.
Arkansas might not have one either.
Arkansas doesn't have one. That's also true. So Tennessee was one of the last states to get one. We got ours in 2019. And then these are all connected through a network. It's called the Innocence Network. And there's a lot of collaboration that goes on there. So that's sort of the structure of how innocence works in this country. Yeah.
I always thought law enforcement, once they get, probable cause suspect, could go to that person's home or apartment, look for confirming, like maybe jewelry that belonged to somebody, or a neighbor who noticed different, unusual behavior. That didn't happen in this case?
No. Nope.
This man lived somewhere.
Yeah. Yeah, the idea of how an investigation should go is rarely how it actually goes. In this case, they felt confident with what they had, which is they got the Crime Stoppers tip, and then they went and they re-interviewed the witnesses, and they put Mr. Whitehead's picture in front of them, and some of them were able to identify Mr. Whitehead, and that was sort of the end of that. Yeah, it's sometimes surprising what gets done, what doesn't get done. Things that get preserved as evidence, stored safely so they can be re-examined later. We run into that all the time, where we know that this evidence existed at some point, but it's gone now. We can't find it. It is either lost or destroyed.
There was a jury verdict in this case?
That's right. Yeah, that's right.
Not a plea deal?
No. I won't say that we would never take a plea deal. It would be very difficult for us to prove a plea or overturn a plea. You give up so many of your appellate rights when you plead guilty. I won't say it's impossible. I'll never say it's impossible, but it's functionally impossible to exonerate somebody after a guilty plea.
That's funny. I'm sure lawyers have told their clients sometimes, I believe you didn't do it too,
But
this
take the
is the
deal.
best you're gonna do. I mean, I'm sure, I mean, even the lawyer representing a client doesn't know for sure whether his client is innocent or not.
Yeah, it's tough. It's very tough. The way the law is in Tennessee, plea deals are explicitly excluded from quorum nobis evidence. So we can't present new evidence in a case where there's been a guilty plea. It's really kind of the end of it. I think if we uncovered, say DNA evidence, something really conclusive that really proves beyond any doubt that you're innocent, I think we could still prove a case like that. But so far we've not run into something like that.
Well, I mean, we had Josh Desert Bell a couple of years ago, and he said he's seen where people are kept in jail for a full year. They'll plead guilty to anything just to get out of jail.
Absolutely, yeah. And I would love to be able to take guilty pleas, believe me.
Yeah.
There are absolutely people who plead guilty who did not do it.
And then they have a felony.
Yeah.
I mean, they made a promise that you plead guilty, we'll let you go free, but
Mhm.
you have that felony on your record.
Yeah, this kind of speaks to your question. Somebody who writes to us and says, I'm innocent, but I took a plea deal, doesn't meet our application criteria, unfortunately. It's just not a case that we feel that we can win.
The problem you're mentioning too is compounded by the fact that often as part of the plea deal, they agree to testify against another co-defendant. So if they have now agreed to plead guilty to a crime they did not commit, now they're testifying against someone else who possibly also didn't commit it. But the goal is to just get out of prison. I mean, one of our cases that we just accepted, both gentlemen, the co-defendants, were in jail for over 2.5 years before they went to trial. And one of them confessed to doing it. He now says he did it just to get out of jail because they were telling him he was going to go to the death, he was going to get the death penalty. And so he testified against another co-defendant who was also innocent at trial. So now you've compounded, you have someone who said I'm guilty, and now they're using that to convict someone else.
Do you see this as an issue of class or race? Or which one?
Oh, those are so intertwined.
Both.
Both.
Yeah, it's both.
We have both, but I mean, it just, so much of it is, just resources, just even the amount of resources at the trial level to defend someone effectively, especially if the police have identified, people have identified that is the person they want. It's just, there's just so many avenues of investigation. It's just so expensive.
Yeah, I mean, look what it cost to take this case back to court. Remove our time. It cost us $40,000 just to get the experts all in one room. That's what it cost us, just the expenses on the case. Most criminal defendants don't have $40,000 to throw at a case. It's just the reality of it. So,
I follow the Innocence projects on social media, and I can't say that I've seen any that somebody's been incarcerated less than 20, 30, even 40 years. Is there a length of time being incarcerated taken as a factor when you take a case?
No, it's not. There are time considerations that make those longer sentences more likely for us to receive, because you have to go through your appeals process first before we can take your case. So when your case is on direct appeal, that typically takes a year or so. That's a rule of thumb. That's just a year that you're just going to have to sit in prison, basically, while your case gets appealed. And then, other appeals can take a very long time. Most people go through their post-conviction process. That can take, actually, a curious thing about Mr. Whitehead's case is that even though it was a 20-plus-year-old case, it was still in his original post-conviction, which, because of some very unusual circumstances, had simply been left open. It had never been closed. And so we were actually able to go back to court in Mr. Whitehead's case and argue some additional things that we typically would not be able to argue. But that's very unusual. Usually you have to go through your entire appeals process before you get to us. That can take 5 years just to go through that alone.
Yeah.
And we are very much the last resort for people. There's really nothing beyond us that absent a change of the law, new evidence that you find without us, something like that. We're the goal line defense on these cases, so it just takes a while.
And also, the projects have not been around that long. So
Also
somebody
true.
that's been in prison for 30, 40 years has not had that opportunity.
Also true, yeah. One of our cases right now, our client's been in prison for about to be 47 years. So, a 1978 conviction.
But Connor's worked on that case passionately for over a year, I would say, maybe two, and the hearing is set for, in August.
August 19th.
So, and the JRU is working with us on that, so we are really, again, it's not over till the good thing happens, but we are really hoping that this will be successful. I mean, this client's amazing, and he deserves to get to be, I mean, they're all innocent, but he's wonderful, and, we're really hoping that this will be his chance to get out.
It's
I
just
know.
heartbreaking.
I know.
It's just heartbreaking.
Yeah.
I mean,
I
this
think-
man has to be as old as me, if not older.
And you also think about the generation of trauma we've now caused to his children who've lived with a father who's incarcerated, to his family. I mean, you just think about what that does to a family, but I mean, and yet these people, like, they have the perseverance and the spirit and the family members that stay connected with these people in prison. I mean, it is remarkable. Like, you are, the craziest way, I think in some ways they inspire us more, that they can like keep on, and they're so grateful and so positive, and you're just like, I would not be that way. I would be like, probably solitary, very angry, but they persevere.
I mean, I go into tears just thinking about it.
Yeah, I've seen that.
Yeah, it is heartbreaking.
Would you say your primary weapon or whatever tool in getting his conviction overturned was the fact that the informant was indeed compromised?
Yeah, there's sort of, I would agree with that generally.
So
yeah.
this was known 20 days before he was sentenced.
Yeah.
Is there not some sort of obligation or a means to find something like that out? Could have saved the state, could have saved you a ton of money
Yeah,
up front.
absolutely. The state could have gone to the judge before sentencing and said, we have found new evidence that really radically changes how this case looks. In fact, many people would argue that the state has a moral and ethical
That's what I
responsibility to
would've
do
thought.
that. Yeah. It's been a while since I read the rule. I think it's Rule 3.8 says that, I may be wrong about that, it doesn't matter. It says that when the state learns of clear and convincing evidence of innocence, that they must bring that to the trial court's attention and seek to remedy the conviction. They did not do that here. I would argue that was an ethical violation. These things slip through the cracks sometimes.
Because of that, does the state have a liability because they messed up on their obligation
Good question.
to this man?
Good question. That is outside of the scope of our representation. Yeah, we do not handle their civil suits. The answer is yeah, that he can pursue that, absolutely. But we don't handle that. We don't take a cut of their settlements if they get one. That we recommend firms that they might choose. But other than that, we are
Is he going
hands-on.
to pursue that, or do you know?
I believe he will pursue that, yes.
But it's a multi-step process. You first have to go through a process to be approved by the governor and some type of a form. Again, we don't exactly go through this,
So there-
but it is not clear cut or a guarantee. There's not like a fixed amount or anything like that.
There's a trust fund that the state has established that gives you compensation if you were wrongfully incarcerated. In order to qualify for that trust fund, you have to be formally exonerated by the governor. So Mr. Whitehead has not been formally exonerated by the governor. He has been exonerated by a court, which has the same effect, obviously. He's a free man. His record is clean. But until he receives that exoneration from the governor, which the governor does not have to give him, it's a clemency standard. It's the same as getting clemency, essentially. Until he does that, Mr. Whitehead cannot recover from the trust fund. One of our clients who was exonerated in 2020 just recently was exonerated by the governor. That's Joyce Watkins. She was the first black woman exonerated in Tennessee. And she was only just, like, last month, given access to be able to file for the trust fund. Yeah.
Is there a petition or anything to Governor Lee for that to happen?
Mhm.
I mean, that's the kind of stuff we can do.
For Mr. Whitehead?
Mhm.
Yeah, we cover that. We handle that application process. It's very slow moving.
But I mean, like, an outreach petition for citizens to tell the governor to please.
Oh, interesting. Not for Mr. Whitehead at the moment. I know that. Certainly, we got a lot of community support for Ms. Watkins, our most recent clemency recipient.
Let us know.
Yeah, I certainly will. Yeah, that kind of thing absolutely helps, and you know, it's about influencing the governor. It's a very personal, you know, person-to-person thing, and that kind of support definitely helps. Thank you.
Making a note.
Yeah, thank you, Quinn.
It's time. Thank you very much for being here.
Thank you.
Thank you.
Thank you, sir.
That was so awesome. I want to put a name in your brain. Have you met Rob Gallen in that review? So he's like
Yeah,
the number 2.
I know Rob.
He's good. I like grew up best friends with his sister. Literally, so I just know him that way. But she was kind of, you know, crazy or whatever. I just assumed that y'all were close or whatever.
Yeah, he actually worked on the course. Yeah, he was
Right, but he was on the same.
he supported us.
Yeah.
Enjoyed it. Great. Very good.
Thank you very much.
So
Tell your dad some
I will.
here's this little article about the shaken baby syndrome that just came out.
Yeah,
There was a big article in here.
ProPublica.
Yeah,
and
okay.
New York Times.
So, that has been exonerated
No, we lost that case.
because the DAs weren't supporting you.
No, actually, the DA did support us. The reason we lost the case is the judge said, everybody agrees that this man is innocent. Nobody cross-examines the expert witnesses. And so I'm being hoodwinked, basically. And he denied us on that
So,
basis.
was he totally conservative?
I don't know. That's sort of my read on him. He also was, yeah, he was also the judge who heard that case originally, and so he's biased. Yeah, I mean, we're asking him to reverse himself. So, you know, it's built-in bias. They have to. They don't have to do this. Yeah, there's no law that he
So
cited
that
no
one is,
legal.
that actually is.
It was pretty good.
And he's maintained his innocence, and this guy maintained his innocence
Absolutely.
throughout.
Absolutely. Yeah.
Anyway, you will be keeping your office in our prayers. Ottawa was a part of MICA, which is like an interfaith, like that's how we funnel that out. But there's a Tennessee statewide one too. There's one in Nashville, it's called NOAA, there's one in Chattanooga. So we could get some signatures.
That would be amazing.
I'm not kidding, and your dad, I mean, your granddad knows us.
We have, I know if you go, but we have cases that we're hitting dead ends with. We can't move them any further. Clemency becomes our only option. And so having a network like that would be amazing as we get some of these older cases that we can't do anything with.
The Memphis MICA group has the justice, like reentry is kind of a big focus of theirs. But I promise you, that would be a great, easy funnel. Sorry, y'all.
Thank you.
No, that's wonderful. That's wonderful. Thank you. Like you're right. Number one, very busy. Number two, you're a new dad, so you don't have time. So if you ever get a chance,
They always were close.
that's just the title, but it is a terrific courtroom, court case, a project